advisory, but it is not a statutory body. It has not been invested with the authority to overrule the chief administrative judge by the legislature. It's an internal appellate procedure. And it is a fact, I think, that this court has to take into consideration. And the statements made by that body are a fact that must be taken into consideration in your determination of whether the original allocation and classification decision was arbitrary or capricious. But that is the function and appropriate role of this court. Was that original decision arbitrary and capricious? The internal standard used by the Classification Review Board was to decide whether or not the the chief administrative judge's decision was unjust or inequitable.
Well, if I understand what you're saying, the proceedings before the CRB are irrelevant to what we're talking about.
Well, I think, Your Honor, just like proceedings before the Court of Appeals involving an appeal from a National Labor Relations Board decision, the underlying recommended decision of the administrative law judge is something that the court does take into consideration. It is a fact in the proceeding, but there certainly was not a finding of fact. There could not have been. There was no evidence introduced to them under oath. There was not a single ounce of testimony. There were statements by lawyers and representatives, none of whom had any direct knowledge of the facts about which they were speaking.
It's only advisory then, that's what you're saying.
In effect, Your Honor, it's only advisory.
In one of the proceedings, the members of the Classification Review Board are named as respondents.
I understand that, Your Honor.
But what relief is sought against them? What's the point of making them respondents?
Well, that was not the decision of my client, Your Honor. I don't know why. The appropriate respondent in this case, and it is our position, the appropriate respondent is the chief administrative judge who originally made the decision that is under attack. Thank you, Your Honors.
All please rise. Hear ye, hear ye, hear ye. All persons having any further business before this Court of Appeals, held in and for the State of New York, may depart hence and appear here tomorrow afternoon at 1 o'clock, at which time this Court now stands adjourned.
I wish so.